Each year, Microsoft Research hosts hundreds of influential speakers from around the world, including leading scientists, renowned experts in technology, book authors, and leading academics, and makes videos of these lectures freely available.
Get started and let the stragglers straggle on in. Thanks for being here. We're super happy today to have Jessica Silby from down the street at Suffolk University. Jessica is a law professor who also has some media studies interests and has written this fabulous new book, which you can see right here, called The Eureka Myth, about the role of intellectual property in the everyday lives of people who make it, like us. Mm-hmm. And I'll hand it over to her. So,
all right, great. Well, I'm really glad to be here. I met Nancy several years ago when at a IP conference, a video gamer researcher asked me if I knew her because she was doing this qualitative empirical work on musicians, and I was doing qualitative empirical work on a range of creatives and innovators. And so we got together and started chatting and had a lot of similarities. So Nancy's right. So my background is as a lawyer and law professor. I also have a PhD in comparative literature. So it's not communications. It's really narrative theory and film theory is where my my other discipline overlap is. And as you will see from this project, I spend a lot of time thinking about language and how language matters and how we create our communities, how we get meaning in relationships, et cetera. So this project started out with I want to say an annoyance, but that makes it sound not as fun as it was. So in law practice, and in law doctrine, we say all the time that intellectual property, mostly patents and copyrights, although we are starting to say this with trademarks as well, that the exclusive protection that IP provides motivates and enables the making and distribution of things that are protected through it. So you wouldn't write a novel if you didn't get copyright, you wouldn't make a movie if you didn't get copyright, you wouldn't develop a big drug if you didn't get patents, et cetera. That it facilitates the recoupment of investment in that work. That's what we say all the time. There are, however, many other ways to explain how this work gets done, why it gets done, and I wanted to figure out how those stories and those explanations matched onto the story we have in law. I wanted to figure out whether there were contradictions, complexities, supplements, and whether they were going to be meaningful for the debates we are having in intellectual property today. And so one of the ways I wanted to do that is not what typically law professors and legal scholars do, which is look at all the cases and the disputes, sort of the 1% of where all the legal doctrine is coming from, and really look at the ground, sort of who is making the stuff, in what kind of organizations, what do they care about, and what motivates them? How do they explain how they do their work, what enables their work, what hinders their work? And so I decided to start collecting these explanations by doing a long-form qualitative interview study. And so what I'm going to do is share with you the results, or partially the results of those study, which, as Nancy says, has just been published in this book, which is, I think, a fun, I pitch it as a really fun book to read because it's full of these stories. So, my analysis is in there, but I know what people are enjoying about this book are the characters, the people that I've interviewed, who are all throughout this book. You sort of get close to them, and I think it's helpful. It's helpful to animate the debate. So I'm going to give you sort of a taste of some of the interview quotes from the interviews to give you a sense of what's going to come later, and then I'm going to set out the methodology, sort of tell you a little bit more disciplinarily how I teased out the analysis, and then I'll walk you through some of the findings. So here is, all the names are anonymized. It was a confidential study for reasons I can explain soon. But so this is Joan. She's a visual artist, and she described that she wanted to make paintings and she wanted to publish them. This was in response to a question about whether she keeps track of all of her work. I asked a lot about I think the background of this was, what is one of your biggest problems in your work? She says, I just don't know where to put all my stuff. I make it. I don't have a place to store it. It's pretty big. And we started getting talk about, well, what happens when it goes out? And she says, well, it goes all around. And then she says, I really wanted to make paintings. And she made really big ones, really small ones. And I wanted to publish them, but I didn't want to own them. So owning them, having them in her house was a real problem. It's like having a litter of puppies, and you find a good home for each one of them. That was one of the ways she was explaining her ideal form of distribution of her work. So this is Dennis. He's an in-house patent attorney in biotech. He's been working in biotech his whole life. He's in his late 50s, so he's seen a huge change. And I was asking him about where great invention comes from in the companies that he's worked for. And he's worked for some of the biggest pharma in the United States. And he says, well, Steve Jobs and Wozniak, they created the personal computer, all right? Cohen and Boyer, they created biotech. But most of the rest of us mere mortals just, you learn from other people. And then the frontiers of science are pushed back gradually through similar ant-like persistence by scientists. So in these two quotes, you start getting a flavor of how people explain what is good work, how you want to claim work, their relationship to work. There's going to be a lot more of this. So I start the book with these two quotes, because sort of paintings as puppies, scientists as ants. There's sort of something funny going on here that does not sound at all like the intellectual property law I practiced for years, or in fact I teach in the classroom. So what did I do? I first interviewed many, many dozens of people. I interviewed over 50 people, but I only coded 50 interviews. The classification of the interviewees are stratified over what I think are relevant categories. I can tell you what those categories are if people are interested in it. But I had to stratify them to get to a sense of relevance. It's a standard interview protocol, so I asked the same questions of everybody. The interview protocol had to be blessed by the IRB. But a lot of people would answer very little for some question and answer a lot for other questions, so they were flowing conversations the way they should be. I always ask more general questions and then narrow down to the more specifics. You let them direct the conversation. All the interviews are transcribed, and then I code them. I use Atlas TI as the qualitative software, not in Vivo. I prefer Atlas, and people are interested in that, we could talk about that. All the transcripts are loaded onto the software, and Atlas allows you to search and sort and figure out where codes are showing up and where codes are not showing up, and it gives you basically a database of language and relationships. Atlas is a software system that allows you to create relationships between documents and categories, and then suggests more relationships that you aren't seeing to help you analyze the qualitative data. So there are lots of different ways you can slice and dice this data, as you can imagine. The primary thing I was interested in is, how does intellectual property as an exclusive right function in the lives of these people, both creative and innovative professionals? And they were artists and scientists and engineers, sort of individuals, but they were also people who were member of organizations. They were lawyers and business partners and gallery owners and managers. So there were people on sort of both sides of what you might think would otherwise have different views on the distribution and creation function or the monetization function, for example. So I interviewed a variety of those people, and I wanted to know how IP worked for them or didn't work for them. And the more general question I was interested in is the motives and mechanisms of their work. I mean, we say intellectual property is supposed to facilitate, is a mechanism and a motive, and I wanted to know if that's what I was hearing. I never asked directly about intellectual property in any of these interviews until the very end. That's just not the way you do these kind of interviews. But at the end, I do ask, and that's to check sort of what did they think they were claiming when they were claiming sort of a durable property right, and how does that compare to what they think intellectual property is, for example. And those misalignments are pretty interesting, although they're not very much in the book. So the book has 6 chapters. The first 3 are where I'm going to spend more of my time today. But the last 3 are pretty interesting, and I'll say reputation is an important chapter because reputation is super, super important to most of the people that I interviewed, and reputation is very hard to regulate as a legal matter. It's very, very slippery, and yet it is the thing that it is one of the major mechanisms and the major motives for doing a lot of what they do, and it is not covered by intellectual property at all. So I devoted a whole chapter to this absence in an intellectual property law for something that was super important to the creatives and the innovators that I was interviewing. All right, so inspired beginnings. So when I talk to folks about either how they began their work in creative and innovative fields, or how they began a particular project that either made them who they are, sort of defined them, and put them on a path, there were 4 major categories of beginnings, sort of origin stories, as I deem them. And they are serendipity or luck, intrinsic or natural forces, play or pleasure, and need or urgency. These are actually categories that folks in other fields have already determined are reasons for why people engage in creative or innovative work. I did not impose this on the data. This came out of the data. And so I was very happy to see that these categories of why people began in the fields or why they began the work that they are so proud of is here because it confirms the robustness of the data. What's interesting, however, about these categories, and I'll give you examples of them in a minute to animate them, is that we don't talk about this as relevant to intellectual property. That we talk about intellectual property as being a carrot in front of a lot of people who are going to be engaging in burdensome and hard and time-consuming work. We don't ever talk about these significant psychological and cultural categories or reasons being how people engage or why people engage in the work. So this is absent from the legal literature. It's absent from the legal debate. And yet it is ever present in the people who are engaging in work that's protected by intellectual property. So let me give you an example. So here, I began as a painter but ended up a sculptor because my paints were lost in the mail. So this is Serendipity. This is a woman who is known for her giant, giant sculptures. She makes these huge sculptures that are really nets and wire, and they flow, and they're connected. They connect big buildings. Internationally known sculptor. But she started off as a painter, and when she had a Fulbright fellowship in India, when she was young, she went over there and she was supposed to do a big show. She was waiting for her paints that she had just bought after grad school to come in the mail, and they never showed up. And she's walking the beach, wondering, what the hell am I going to do? I have to put on this show, and I don't have my equipment. She's walking with another woman there, and she saw all this found objects, and the woman said, well, I don't know, a lot of painters ended up being sculptors. Maybe you can make something. And she's like, yeah, I can make stuff with what I found here. And she has forever actually been the sculptor who makes things with nets and rods, the kind of things that were on the beach in India. So that's serendipity. This is need or urgency. This is an oncologist who said, I was always fascinated with the eye and blindness, especially after my mother was diagnosed with AMD as age-related macular degeneration. And so I combined my oncology background with ophthalmics. So this is a woman who started off as a biologist. She started a company, a biologic company, and it has a blockbuster drug that treats AMD. And she talked about the origins of that drug and that business in this way as problem solving. This is a VC in a small energy startup that's no longer small anymore. Great science comes out of labs from people who have the freedom to play around. I call them juvenile delinquents. So I asked him, tell me who in your work generates the most inventions. Like, who are the people in your company who either you're getting a lot of patent filings from, or they're creating the stuff that you're really able to commercialize. And he says they're the people who are always breaking the rules. As long as we give them some freedom, a lab space, and some parameters, if they will figure out a way to get around all these other things, break these rules, and they're the ones who are generating the most important stuff. So that's play or pleasure, and this is intrinsic. The song just came to me nearly fully written. So this is a singer-songwriter. All of the interviewees, by the way, do their work pretty much full-time, but not all of them make a good living out of it. So there are people who are, very, very well off, some of them who are not. That was one of the categories of stratification. She talks about how one of the songs that she's made a lot of money on was one of these things that she just it just came to her. Not all of her songs are like that, but that was the origin of one of them. So as I said, these categories are not really very surprising from the perspective of creativity theory in psychology or sociology, but reasons other than property entitlements are given for beginning work. That makes sense for everyday people. The fact that IP is not present as an instigator really disrupts dominant legal theory and legal policy, however. That IP is not there at the beginning in the explanations is something that when I speak to a room full of legislators, for example, or I speak to a bunch of judges, that is strange to them. That's because that's not the way they've always understood the reason that and how law functions. And then the next question that is always asked is, well, what about everyday work? So maybe it's not there in the beginning, there's this inspirational thing, or there's this problem. What gets you working every day over the hurdle of the inspiration, hard work every day? There has to be an incentive there, the idea that you'll be able to recoup through an exclusive right. That's got to be where IP is, right? And so, of course, that was one of the next questions I asked, because that's what I was thinking. Like, I don't go to work hard every day, not for the money. Like, sometimes to grade a stack of exams is high. Like, you better be paying me my salary, right? Now, so where does it come from there? And so when you talk to them about their everyday work, what you'll hear in the book is there are certain tropes that they use for what facilitates everyday, constant, stable work, what enables them to get the work done every day. So they talk about time and space a lot. That is the trope of having enough time and autonomy over their time. So I need 8 hours of uninterrupted time. I need the time. And they talk about space, this romantic idea of Virginia Woolf's room of one's own kind of thing. They talk about their studio, they talk about their lab, they talk about the cubes, the open space, for example. They talk about the importance of the space and time configuration in the flow of everyday work. And the rhythm and propulsion of everyday work, that is just work makes work. Once I'm started, I'm going to keep going. There is an everyday nature to the rhythm of it that is what motivates them. And I wouldn't say motivate like I'm looking for an end point. They really are what they do, not what they make. That's the sense I got from most of the people that I was talking to, that they define themselves by the everyday work that they engage in rather than the output. And that, again, is disruptive of intellectual property law doctrine. That is, we talk in terms of work, the work in intellectual property, the copyrighted work, the patented invention. What these people are talking about is labor. They're talking about everyday work, working rather than work. And you know, they talk about work being really, really hard. And it's not a burden, like, you know, walking around with this big boulder on you. The everyday work of working really hard is glorious. It's sort of like it's sort of where they see the value, the dignity in the work. So they talk about the dogged pursuit of a novel's ending, for example, how crafting a story can be painfully mechanical. Creating software, a program, is like a military operation. Creating music is like bricklaying, putting these pieces together. So these analogies or these metaphors of durable, hard, laborious work to intangible products was actually very interesting. And to me, that suggested what they really cared about, this is where they saw the value of their work. So here's an example. I think of writing having some similarities to exercise, it being something that I need to do every day. There's the everyday nature of it, what gets her working every day. It's not really explicable. There are plenty of people who don't have to exercise every day, but when I do, I feel better. So what makes her a writer? How does she work every day? It's the kind of thing that she just has to do, and it's like exercise. It's physical for her. Here's an example of time and the value of time to this artist. I usually work pretty small, just in notebooks, and my agent was like, well, you got to make bigger ones. And the gallery said, yeah, you need to make bigger ones. There was laughter in the room because the gallerist was there. It was like, yeah, but you know, I could spend a long time working on the little ones, so you could charge for them. That's what the artist was saying. And they're like, her agents, no, it's that size. It has to be that price. And she says, I just don't understand it. So she says the value of her work is how much time she puts into it, how hard she's been working on it. But the art market is going to be determined by something that she just doesn't understand. So time for her is what is meaningful, whereas the way the market is going to value it is quixotic. There were a lot of natural metaphors in their explanation of everyday work. They would talk about harvesting inventions. A vice president of a company would harvest inventions through a chain of command, seeding ideas to scientists. Writing is like fishing. These are natural metaphors, and for those of you who don't know, intellectual property will not protect natural things, does not protect facts, does not protect ideas, does not protect laws of nature. So the idea that how they are describing what is being made and what is valuable in natural terms is the beginning of a misalignment, a profound misalignment between how intellectual property maps onto creative and innovative work and how they are describing their creative and innovative work. Other metaphors resonate with the family structure, and this, once I say it, it will be obvious to you. People talk about their work like children, or like family, or like puppies, for example. Someone comes to us here and says, I have a story about a boy and his dog. This is a company who takes like toys or media properties, he calls them, like the Star Wars property, and figures out how to put them on lots and lots of different platforms and monetize or commercialize all those different platforms. And his company creates those other backbones to the other platforms. He says, and so he has a lot of creatives on staff who are creating these other stories. And he says, listen, they come, I have a story about a boy and his dog, and we read it and we go, wow, it looks great, unrelated to a client's work. We partner with them. We don't take it over. We're different from other companies where we don't say, oh, right now we own your property, because the work for hire doctrine would demand that the company own the property. We partner with them. We take it out together. It's an ethical thing for us. It's their baby. It's their child. We don't believe in taking it away from them. We believe in partnering with them. Now, this is an example in the interviews. When he said this, I had my sort of lawyerly moment where I'm like, yeah, right. Like, that's, what he's saying, he's ethical. He's not like all these other people. He partners with them. I want to know exactly what he means when he says that. What kind of property distribution is he talking about? So I want people to know that when I engage in these interviews, there are a lot of follow-up questions to moments like that. And so I got the split agreement that goes with the employment situation here, and you figure out what exactly is he talking about. And this company really does consider the work that people do, the creative work, so part of who they are that they're not going to, the work for hire doctrine applies very, very loosely in this company. Now, not all companies that I talked with had the same kind of explanation for how they divide their work, but many, many people talked about what is that people feel towards their work the way they feel towards their children or feel towards their family. That it's an emotional connection, and that of course leads to overreaching, a lot of overreaching in the property context. Other metaphors are with regard to tangible claims. So when they start talking about how they own or how they claim or how they want to divide what's theirs from what is others, so this is property talk. There's a lot of putting your hands on things. Value you can put your hands on. That's a patent portfolio. He's talking about one of the reasons we put a patent portfolio together for investors. It's value you can put your hands on. Well, it's not. That's not at all what it is, but that's the way he's describing it. Breaching DRM is like shoplifting. Patents are chits for trading. Taking an idea is stealing someone's homework. I love this one. Plagiarism is standing on someone else's scaffolding. The idea of taking someone's language is standing on the scaffolding of something, and you got to think, like, what is the scaffolding around? It's sort of an interesting metaphor. And what's interesting about these, again, is that so intellectual property protects intangible things. It is a random, largely policy-driven line in the sand between what is protected and what is not. We could change that line with just a flick of a switch in Congress. And yet the way they're talking about it is in terms of tangible things, where that line is pretty clear. The difference between my bag and the rest of the property in this room is pretty clear, my house and your house. Tangible property claims are not ambiguous, but intellectual property claims often are. And so they're putting them into these terms that are antithetical and really don't fit onto intellectual property regimes. And so what I'm hearing all the time is this misfit between what I know to be IP rules and the professional values of the people who are governed by them. And so one of the things that then one has to wrestle with when you see this misfit is, what does it matter? How is the misfit? People are getting along maybe anyway. And we have we care a lot in legal regulation that there is an alignment that is optimal between the people who are being regulated by the law, the reasons for the law, and how it is operationalized. And if there is such a big gap between how people imagine claiming in value and the way IP talks about itself, I can't help but think that there is some sort of problem, which I think we are actually seeing in the public debate. So how does this mismatch manifest? The mismatch manifests primarily through over-enforcement and under-enforcement, and often also by mistake when they, before they understand how it works. So in the mistake context, you'll hear people say things that are wrong, but that reveals what they care about. And then when they do or do not, whether they know or do not know, they will then overclaim or underclaim what they have, which also gets you a sense of where they would draw the boundaries. So I'll give you some examples of that. This is important because the balance that intellectual property strikes between exclusive rights and what's in the public domain is a balance that is supposed to protect the public domain for everyone to work with it and optimize private rights so that you will recoup what you made. We're not going to give you private rights if you don't need them. Intellectual property is otherwise wasteful. So over-enforcement and under-enforcement is a problem from regulation standpoint. So here is a painter. Look, ultimately I paint because I want to share my visual sense of how I see the world, how I see color with other people. I think I've got to not be totally possessive about that. So this was in response. I always ask questions that tested the tolerance of what would otherwise be infringement. So I asked him, how would you feel if somebody put paintings on a t-shirt and started selling them on the corner? He said, I got to not be totally possessive about that. Like, that's, my work is about sharing, or just sharing my sense of the world. So long as someone is doing it in a way that I felt was up to quality, you know, so now he's switching. So on one hand, he's under-enforcing his copyright, and here, he's going to over-enforce, because if he doesn't like the way he's doing it, if you think they're degrading your work, that's one thing. All of a sudden, he's going to want to assert some control if there is some critique of his work or it's a way he doesn't like it. Now, both of these, this is under-enforcement. He's not enforcing the full extent of it. Putting a painting on a t-shirt would be copyright infringement if it's a verbatim copy. This is not enforceable. This is probably a fair use, a derogatory or a critical representation of someone's work is probably within the fair use context, but he wants to enforce it. So that's an example of both. This is a venture capitalist in the telecom industry who used to work for Microsoft, actually. I think that's the first time I've been able to say that, but a long time ago. We talk about, like in that, you know, in the context, we talk about patents we're filing all the time, and we say we just can't believe that some of these things are novel and not obvious, but we feel like we have to have them at the very least so that we can wave them in somebody's face even though it's a kind of nuclear war. So this guy's not making any mistake. He knows exactly how the patents work, how the patent system works. The meme of nuclear war and patents is, at this time, wasn't so common. This was 4 years ago. It has now become the thing that we are all talking about. But he's going to he's going to over-enforce ambiguous and overbroad patents just to stare down competitors, even though he thinks they are unenforceable. Here is a musician who says, ripping CDs is just free marketing. I mean, because people that actually buy CD is going to still be there, you know. But I feel like if you're not going to buy it and you're going to give it to a friend, great. So there's the under-enforcement. She's going to let people rip CDs for good reason. If you're going to give it to 5 friends, that's fine. Because I'd rather you have it if you're not going to buy it. I mean, I'm not saying I want everyone to do that. So she's not saying she always wants that to happen, obviously, because like I said, I'm still depending on the sales. But I mean, I discover a lot of good stuff by someone just bringing me a CD, you know. So she's striking her own balance in the over-enforcement and an optimal, to create an optimal enforcement. And she thinks she's in control of that balance. Now, why is she changing the balance that copyright has otherwise struck for her? Why is she doing that? So this is not the how of the mismatch, but the why of the mismatch. And you can see in this quote, she's doing it, one, to build an audience. She wants to build an audience. We can either call that market share or relationships with people. She wants to build an audience. She also understands that sharing is productive of other goods, that there is a productive element to sharing freely. But she's also doing it to make money. So building the market share is to make money, and building the market share is to have relationships with people. So these are the 3 primary categories of why people rejigger the balance for themselves insofar as they are in control. One of the things I say at the end of the book is, you're lucky if you're in control. I mean, most people are not in control of how intellectual property affects them. And it's naive to think that we are in control of that. We are really at the whim of it. But so people mismatch, over-enforce or under-enforce to make money. They over-enforce or under-enforce to build relationships. Usually it's under-enforcing to build relationships. And they often over-enforce or under-enforce to enhance autonomy over their professional trajectory. And that's about the time and the space. They're doing it to create their own situation as best as they can. So here's an example of in-house publishing company saying something like that. He's counsel at an in-house publishing company, a for-profit publishing company, and he said, we took all of our DRM off because it was driving customers crazy. And I don't blame them. This was a really hard decision for this company. He had to really lobby for a long time to take the DRM off their content because people were worried that stuff was going to get stale and it was going to be too leaky and they were going to lose money. But he had said we had 2 customer service people doing nothing full-time but holding the hands of customers who paid for the stuff and couldn't use it. I said, this is nuts, so we lose, so people shoplift. You know, it happens. It happens. It turned out to be a great choice for this company. They didn't lose nearly as much money as they thought they were going to lose. So this is an example of under-enforcing, letting leakiness happen in order to build the company stronger. So that's about relationships with consumers and making money. Here, this is an in-house patent attorney who's trying to convince scientists to engage in patent disclosures, to file patents with him. He says to science, what I want is something I can trade, that is, the patent will help me trade. I'm not interested in asserting these against anyone, so I'm not interested in using the patents to claim rents from somebody else. I'm looking for something that either gives me a quid to trade, there's the quid, that is, you have something, I have something, let's collaborate and trade, that's cross-licensing, people do that a lot, or we patent it first so that some other company can't patent it and then come to us for $100,000 a year royalty, so some other person can't use it offensively to prevent us from doing what we're doing. So he's using the patent system, explaining how the patent system is going to work to help scientists keep doing what they're doing. This is basically a justification. You want to keep doing your research? I need to get these patents filed so that you can continue. This is about autonomy, professional autonomy, and everyday work. And it's a form of under-enforcement. This is not how patents were initially imagined to be used. People use patents offensively most of the time to get rent from them, not defensively to protect other people from attacking them. This is a last example from this category. This is an author who says, I never sell a book until it's finished. I don't take an advance because it's too nerve-wracking to have a deadline. I've worked on deadline for years as a journalist, but that's a different matter because I'm always terrified with a book that I won't be able to finish it. I mean, because it just means I have to work my ass off doing something else. Well, not anymore because now I live off my royalties. Notice, like she's figured out a way to manage it. But in the past, I just kept doing, for example, I might have a weekly column in a newspaper or something like that. I could knock it off in a day and a half, and the rest of the week I could work on my book. So she is under-exploiting her copyright. She could transfer her copyright for a lot of money today and then to a publisher, but she's not doing that initially as an advance. She's not doing that because she wants to be free to write at her own speed, at her own time. And so by the time the manuscript is done, the advance might be different, it might be less, it might be more, but she doesn't care that much. What she's doing is she's trading whatever advance she's getting for control over her time. So that is the under-enforcement to establish autonomy. So I think what this misalignment, the under-enforcement and over-enforcement exposes are other stories, the other stories that I mentioned at the beginning, values of collaboration and sharing and cross-licensing, for example, and self-determination in the breach of what is otherwise an orthodox IP story is that we need IP to incentivize the production of more stuff because we need to recoup through IP the value of our investment. There are lots of, that is just not the story, the dominant story I am hearing, and it's not the only story, definitely not the only story I'm hearing. So this mismatch tells me more. Now, what you do in qualitative work is you try to figure out what some of the hypothetical relationships might be between these categories. So I'm hypothesis generating. I'm not drawing conclusions because I can't say how this stratifies over larger population. But this is what I'm seeing. I am seeing, so not much misinformation to make money, not much over-enforcement to establish relationships, but in all the other grids of the forms of the mismatch and the reasons for the mismatch, I can see them correlating, and predominantly under-enforcement is the major form of mismatch, and autonomy, enhancing freedom over your own creative and innovative work is so important that the misalignment, all three versions of the misalignment occur. So there's too much IP, essentially. They need it less than they have. And freedom, sort of the dignity to be free to work as you want, which is not what we talk about intellectual property as being at all, is one of those things that is so important that they are squishing it and stretching it to IP to achieve it. So that, to me, is pretty interesting. And what it tells you is that IP is just one small piece, that IP, as traditionally conceived, is really one very small piece of scientific and artistic progress, which is what the Constitution says IP is supposed to be for. And if you figure out how do they make money, that is, how do they make do, which is what we think IP is for, is to help you make money, IP is actually at the very bottom of the way they actually make a living. Even folks in pharma, even folks in filmmaking, the way they describe earning a living and building these relationships and growing their business is through contract, through first mover advantage, complementary products, building a market share by giving away or under enforcing. Personal relationships, loyalty, and reputation is dominant among the stories about how they build and why their company is so successful. And they do talk about defensive uses of IP and some offensive use of IP, but really not as much as one would think. And so the diversity of revenue streams here is really an old-fashioned way of doing business. You know, when I speak at Sloan next door and I put that thing up, that slide up, they're like, of course that's how business works. Like, what did you think? And then I said, then why is everyone talking about IP as it is the essential mover in our digital age? Why are we saying that it is the cornerstone of technological innovation? It really is not if my data is the beginning of what I will find if I do this more and more. Open and fair competition is really where a lot of the innovation comes from, not lockdown technologies. Community and identity-centered innovation, that is innovation that happens in collaborations rather than in the Eureka moment in a garage, for example. IP is present, but is really not uniformly dominant. And so the incentive story, I think, is really replaced by these other stories, or at least it coexists in a very robust way. And so one of the mysteries to me, as someone who lives in the legal world, is why is the incentive story so persistent? That is, we talk about it all the time, this origin story and what IP is for. You can't read an IP case without hearing it, a mantra. And so I have two hypotheses, but they are just guesses. One is that the incentive story is a simple one. It is a simple carrot and the stick, rational actor model where law and economics has dominated the study of law and regulation for 50 years. It is a simple story. And the story that I'm telling is much more complicated. It's a much more complicated story about how people work, why people work, what facilitates work. And as between the simple and the complex, people just default to the simple. The other suggestion is that the default to money, that is, we need IP to recoup investment, just feels more objective. Everyone needs money. We can measure money, how much money goes in and out. And the objectivity of that baseline feels like we can all agree on it, but when we talk about relationships, we talk about autonomy, we talk about collaboration, that feels fuzzy and subjective. It feels like something that maybe people will have different levels of tolerance for, and money is one of these things that is a common denominator, everybody needs it. You know, maybe you have some other suggestions. I am open, very open to the persistence of it. I mean, I have some cynical ideas too, but I won't talk about those here. So one of the things that I'm working on now is trying to figure out how can IP be better aligned? That is, I think we need to keep our systems leaky. That is, perfect alignment is a bad idea. Perfect enforcement of law generally is a form of dictatorship. Like, you can't live in a world where law is perfectly enforced. So then the question is, what amount of flexibility should we be building in the system, and who gets the benefit of that flexibility? Currently, we have fair use regimes, we have exceptions, and we have private rights. There's a lot of critique that those fair use regimes and the exemptions are not clear enough to give the flexibility to users and prosumers, and that we should be rejiggering that balance. What is the kind of flexibility we need in which way? This study suggests that people have too much. They don't need as much as they have. We could easily roll it back and not affect whatever incentive might actually exist. There's Howard Gardner over at the Harvard School of Education talks about good work being about alignment, optimal alignments between your work and your place of work and the regulation of your work. And I think that's what I'm thinking about, is that optimal alignment really is something we need to work more towards. And ironically, that's what IP is about. It's about balance. Intellectual property is about striking a balance, which makes it different from property, real property, for example. And I think that these interviewees are talking about how they strike a balance, and we should probably listen to them. So that's the first 3 chapters, and I would love to hear your thoughts and questions or hypotheses. Do I do the calling?
Sure.
Okay, Charlton.
Yeah, thank you for that. And I'm with you on the instinct to say IP often doesn't have a particularly nuanced sense of why people do things, why creators and artists and producers do things. I feel like there's 2 thoughts. So one is I have a different answer for you for like why we do this.
I would love to hear it, yeah.
And I'm thinking of like Mark Rose's book, Authors and Owners,
Yeah.
right? So it's like maybe there was this move in 1710 that said this was always a law that was actually regulating distributors. And it was like, why would a distributor want to invest in a creator? But then they pinned it to authors, and ever since then, it's like it's always had to justify itself about creativity. And creativity is multidimensional, and money's only a part of it. In fact, artists often have a kind of contentious or ambivalent relationship to money. And so this distortive quality of like, look, there's production, there's reputation, there's meaning, there's expression, there's sales, but then we take this mechanism. But the mechanism was really about, why would a publisher say, I'll take your book and I'll make 1,000 copies if the guy next door can then make 1,000 copies on the cheap, right?
Right.
So it's that weird gap. So in some ways asking like, is this matching what creators actually do, like misses the fact that this was never really for creators in the first place. And so maybe we're still hanging on to this like, 300-year-old swap a little bit.
Yeah.
But the other thing I would say is that I wonder if there are moments in here where, when you're talking about over-enforcement and under-enforcement, it's not exactly the premise of IP that they are either using, misusing, overusing. It's business models that have built themselves on IP. So for instance, when the guy says, I stripped the DRM because it was annoying to my customers, I was having to pay for the problem. There's nothing in copyright that says you have to impose DRM. That's one model for how you would extract revenue based on a financial relationship that's then equipped with DRM and the Digital Copyright Act and all that stuff.
Right.
And similar things about the advance, right?
Right.
It's not that when you get an advance you exchange copyright at that moment. That's a contract that says I'll pay you twice for the exchange of information, the rights exchange that happens when you hand me the book.
Right.
So saying I'm not going to take an advance because that gives me more freedom is not actually an IP adjustment. It's I don't like the contractual model that my publisher's offering, so I'm going to forego that model because I like the independence.
Right.
So I'm wondering if there are moments where like, I don't want to argue like to defend copyright because there's a million problems with it. The idea of like, we thought of copyright as this is going to be a rights assignment so that in certain conditions people can act on it. One of the things we've seen in 200 years is we went from lots of people in the 1800s and 1900s not bothering with copyright, they didn't even register it, to this thing of like, if you have your copyright, you're supposed to act on every single copy, every little moment, you're supposed to extract every little bit. And then authors and artists and producers saying, well, sometimes, and I'm glad I can make an income, but I don't, and what they're struggling against is either the application of copyright, modern application of copyright, or these business models that premised on copyright, but then add a whole bunch of other.
Yeah, I like this idea of industry structure, pre-channeling certain uses. I think that's helpful. Let me just, I'll get to that. So what you say is true. Mark Rose's book is very important, and that's going to my cynical response at some level. And I do think there's some good theoretical work out now that suggests that how intellectual property actually works today is a form of post-industrial capital. It's a form of shareholding, and that we should be thinking about in terms of a trust relationship, and that it really is a corporate asset rather than anything else. And I would agree. I would absolutely agree. That is how it is functioning. That's how lawyers collect it. But no bill will pass Congress or even get past a committee if we say what IP is for the companies of the world. It always boils down to the employees facilitating certain lifestyles. It's about the authors and inventors. And that's in part because that's what the Constitution says, authors and inventors. And it's because of the ideology of American individualism in the United States. It's got to be about that one person or that one individual. If we were to accept that it is about corporate ownership, what we would then have to wrestle with, and I'd be fine with that. That would be more honest, truly. What we would then have to do is, okay, all these individuals who are either parts of companies or independent, we still have to motivate them to work. And what do they care about? They care about the terms of their job. They care about terms of labor. So what this then becomes is a question about labor relationships. That is a super important move. Because I've been accused of being a Marxist when I say things like that, but that's really if this is really about labor relations, we need to worry about how these contracts, we have no control over how we negotiate these contracts. Non-compete agreements, for example. I mean, there is the myth of consent and negotiation over these things. We cannot negotiate these things. So I think it would be a very healthy move to say what this is really about is about corporate assets and company ownership. But I really doubt that that is where the political conversation will go, especially since the most recent downfall of strong IP, which is SOPA and PIPA in the past two years, really came from this groundswell up of internet users. And so that just fomented this idea that lots and lots of individuals really care about intellectual property in a different kind of way, and to sort of wrestle it back from corporate ownership. But I agree. The other thing I'd say, though, about this is when I interviewed corporate entities under the guise of confidentiality, which is why it was so important, they confirmed that intellectual property was not all that critical to their corporate welfare. That pharmaceuticals, they need patents a lot of the time, but not as much as you would think. And what makes the drug so expensive has a lot to do with direct marketing to patients. And so even if we buy that distributors claim to need the IP to do it, why else would they do it? That's not really what I was hearing most of the time. I'd say they do it more, but not as much as one would think. So I think I've sort of answered the industry structure. There are a bunch of people. So one of the things I could do next is, and some people are already doing this, is figure out how different industries structure their relationships with creators and see how that manages the different. So people have done that with Hollywood. People are doing it with television. You could do it a lot. There's a lot of work on that. Bench scientists. What you would trace is how the exploitation or non-exploitation of whatever right you might have changes as it goes up the chain in the organization. That would be really interesting. But in the end of the day, what I am seeing is that people are just not using as much as they have. So that author is not exploiting what she has. She's rejiggering it. Most of the companies are doing that too. And in law, when you have more than you need, it's called waste. In intellectual property, it's particularly bad if you have more than you need, because the people who are the losers, if you have too much, there's a whole group of people in the public domain who are excluded from something that you claim not to need, but you can control, and it's totally at your control. Whether you get that cease and desist letter is totally up to the property owner, not to you. And so if the boundary is drawn too large and people are under-exploiting whenever they want, there actually is a tangible harm to the rest of us, and in fact to them, when they are users themselves. We try not to draw the lines too big in intellectual property for that particular reason, because it's so hard to know when we are infringing. Somebody else, yeah.
Yeah, it's really fun stuff. I'm Ian Condrey, an anthropologist at MIT.
Oh, great.
And yeah, really enjoyed it. I follow up a little bit here on this question, because that was my cynical view too, is just ways for companies to extract rent, and they'll call it whatever they want, but it's already set in stone, and the lawyers enforce it anyway, so it doesn't matter what the Constitution says, actually, about fair use, for example.
Right.
But then the comment part is to say, I'm not entirely convinced there, because, or I wonder, maybe there's a quibble, maybe it's just a quibble. But when Jack Valenti is arguing against VCRs, he's not arguing for the creators of movies as much as for the destruction of an industry by the evil Japanese.
Right.
And I think a little so too with the Mickey Mouse infinite extension of copyright, that Walt's not worried about Mickey Mouse anymore.
No.
You know, but so the idea that it should be for a company is not so far, it seems to me, from where they're enforcing copyright. But
Yeah.
I don't know. The legislators probably have a hard time saying it, but maybe, is it the judiciary feels differently? I'm not sure.
Yeah.
I mean, I think you're right. It's a bait and switch, the innovation and creative idea, but there's leakage even in that logic. But my question, and I was sort of thinking, I'm totally with you, and it's wonderful stuff. And I thought one way to extend it, perhaps, and if part of the mission here is to say, look, we need a better understanding of how IP works, and one part of it is motivating people, artists and creators and inventors. The other part of it, it seems to me, that could get the corporate side a little more sympathetic is the notion that, in fact, like the anti-DRM guy saying, we got to open it up or else it's bad business even. In fact, and you say, well, is there any test case of this? We say music is the test case where Napster becomes free. Now it is free, but anybody can get it for free. But there are ways to make a business even in the midst of free.
That's right.
And so it seems to me that's a way, because the companies themselves, I think they know this.
Yeah.
You know, they're not going to writers and saying, hey, we'll enforce your IP. That's why you should be with me.
Right.
So,
Right.
Another way
Right.
to say it's that broader
Yeah, so what's so interesting,
business too.
what I want to say about Disney and Jack Valenti is that those were really identity claims. They sounded in property claims. What I made this really important thing, I should be able to keep it as long as I want, and whatever value people get at it, I should reap the benefit of that. But really, Disney didn't want Mickey Mouse, didn't want porn Mickey Mouse. He didn't want derogatory Mickey Mouse. He wanted to be able to control Mickey Mouse because Mickey Mouse was his baby. And we have lots of good historical evidence suggesting that the reason he wanted to extend copyright to save Mickey Mouse was because he didn't want anyone else touching Mickey Mouse. He knew that Disney was never going out of business. And that's an important thing, the question of whether we need IP to protect the business. What I think you said is true. I was just arguing with this student the other day about this who was complaining that that film is going to go the way of music. And I thought, I don't even know what that means, because the way of music is pretty good right now. I mean, some people, there's a lot more music, and a lot of people are listening to a lot different music. So when you say the way of film is going to go the way of music, do you mean that the film industry is going to change and disaggregate the way the music industry has done? And yet that really upset him. He didn't like the idea of the big 6 movie companies not still controlling the making of movies. And what he thought is people were going to sort of, the value of the product was going to be lower because it wasn't housed in this glorious space. But what I said to him is, it is inevitable that industries shift over time. And if what we're seeing is the renegotiation of the intellectual property line is that it is promoting the shifting of industries in ways where innovation is occurring, I think we should embrace that. And the VCR is a perfect example of that. The music industry is an example of that. I am sure the film industry is going to go that way. I mean, just look at Netflix and Amazon, the way movies are made differently now. We are going to see different industries building up around it. And one of the I'm not a cause and effect kind of person, even though I'm a lawyer. I'm more like trying to be an explainer. It would be fun to try to figure out how the change in intellectual property relations is related to how these industries are developing out from under them. I mean, it's not that musicians don't care about exploiting their copyright. They still do. You hear all the arguments about Pandora royalties and stuff like that. But the importance of copyright in those spaces for the distributors is really quite different today than it was. So I do think industry-specific studies, like an anthropologist could do better than I can, would be really helpful to compare. I mean, the pharma industry is just ripe, but you can't embed in pharma. They don't let you do it. It's just been tried, and it's not getting anywhere. Yeah, Nancy.
Well, what you just said about musicians and Pandora, it seems like a lot of the argument about trying to enforce IP for songwriters with Pandora is actually sort of a different space where it's almost like If the CEOs of Pandora were not taking home hundreds of millions of dollars, but were earning $60,000 a year, I don't think they would care so much. It's the sense of other people are getting rich on it, and I'm not getting a fair cut.
It's a fairness
Right?
argument.
So it's a fairness argument about where do the assets go.
Right. And intellectual property has nothing to do with, I mean, on the one hand, we could say intellectual property has everything to do with fairness, because the way we strike that balance has to do with equity. It has to do with distributive justice. Who's going to get to use things for free and who's going to have to pay. On the other hand, we've never talked about intellectual property rights in terms of like equality or equity. And what you say is true. I mean, I see all over the data the kind of infringements that they tolerate are ones where they can sort of explain both sides. There's like a fairness. Well, they couldn't pay. It's okay. It's not a big deal, But where, that gallery is taking home so much money, and I still can't pay my rent. Like, that's wrong. If you brought that to a court, like it has no relevance to intellectual property law, and yet that's exactly the way the artists and, in fact, the business people think about it. So one of the projects that I've started doing is trying to attach progress, the notion of progress in the Constitution, to equity, to notions of equitable distribution. It is not in the history of the Constitution, but I think it is shortly after I think you can make the argument that the kind of progress of science and art that people care about is related to equitable distribution of goods via access and ownership. And that would be, I've been accused of a lot of things. That would really start, that's trouble. That's trouble for property theorists, But I think that's really what people do care about. And as a lawyer, I know that I can convince people not to bring cases if you can settle on fair terms. When they're really going to push it, even when they're going to lose, is when they think it's profoundly unequal. That's when they're going to do it. Even if they're going to lose, I want to skewer you in the media. I don't care, because what you've done is wrong, according to my rules. Yeah?
So I really appreciated the methodological insights that you offered, and I wonder if you had moments when you were interviewing people and they expressed maybe a interpretation or understanding of copyright that's closer to what we were just talking about, where their belief about how it works or ought to work is different than how it does work.
Yeah.
And how did you handle those moments as an interviewer?
Oh, right, so that's really hard as a teacher. That's a really hard thing. So usually the way I literally handled it was I wrote down on the piece of paper, and then I turned off at the end of the interview, I turned it off and said, let's go back and talk about how you are confusing plagiarism and copyright law, for example. Yeah. Right? Because I thought it was at some level I wanted to help them. Where it happened most with copyright was attribution problems. Like, they thought that copyright mandated attribution, and that failure to cite, plagiarism, was a copyright harm. And that is just not even close to what copyright does. Attribution is not nowhere mandated anywhere in any of the intellectual property statutes, except possibly trademark, but really loosely. So that was one of the major misunderstandings, and they were really upset about that. That really upset them. Thought it was just wrong. Another one was in terms of a lot of people talk about idea stealing. Took my idea, so a different kind of plagiarism. And ideas are not owned, not in patent, not in copyright. But I have a hard time when I read the interviews trying to understand what they mean by ideas, really. But they don't mean what. They clearly think they own more, I think, than the intellectual property statutes would allow them to. So it's interesting. Their flexibility in some, lots of flexibility, lots of tolerance, also gives way to very sort of strong moral claims otherwise, which I think have a lot to do with personality issues rather than anything else. Not really. It's not about investment, although sometimes it is. Yeah.
So kind of a methodological question. So you've got a tricky situation where you're trying to counter a story, the incentive story that's being imposed on the messiness of creativity.
Yeah.
But you're counting on people's stories about why they made stuff, which is itself a story. So I wonder, how do you deal with the moments where you're like, there are stories about why you create that are also awfully it just sprang out.
Right.
For the people, or I just want to.
Right. I don't want to own things. I want to give them away like puppies. Like, what is that? Right.
So how do you deal with the constructions
Right.
that they're
That's an important question. So
where are there places where you worried that you weren't?
Right. So I usually get that from the economists in the room. So this is your talk, what people say, not what people do kind of question. And so fair enough, it's an important question. So I'll say, just first of all, I really care about how people describe their life. I really think that the language we use and the way we assert ourselves through discourse is really a primary way of constituting ourselves and our relationships. So I actually think the way we explain things matters a lot, concretely a lot. That being said, I really I tried, and this was from my training not as my training as a qualitative researcher actually came later in life. My training as a lawyer was really helpful here. I really treated this as sort of depositions. They would say something, I would then try to test what they said through other mechanisms. So when you're collecting facts in litigation, and you're doing a deposition, you want to make sure that it's not just a one-off, that they're going to repeat what they said over and over again in lots of different ways through different examples just to sort of nail it down. And so I would do that. So they would say, like, I didn't really want to own it. I wanted to give it away like puppies. And then later on they'd say something, and I would try to ask a question that I think would get a similar answer and see if they gave me the same kind of answer. So are they consistent rather than just telling me a tale? That said, narrative arcs, like the way you explain things, like where you came from, why certain things are important to you, those have explanatory force in the world, and that's really what law is all about, generally speaking. Unfortunately, so much of law is about the persuasive story, and so I think insofar as that's what we care about in law, and that's how we make laws, and that's how we adjudicate laws, we should be listening to their stories too. Their stories should matter just as much as the one that lawyers craft. So then it's just a tit for tat. But I agree. I did collect a bunch of documents, and I asked a lot of questions about how people behaved rather than how they explained things. So tell me about, how you negotiated that contract and what were the deals. So I asked a lot of factual questions that would describe behavior as well to do that. But yeah, it's an important question for methodological purposes. Yeah.
Can I ask another methodological question? I know we're over time, but in terms of the 3 categories that you mapped out on your matrix.
The 3 different ones, right? So the different kinds of mismatches and the reasons for them. Yeah.
So the making money, establishing essential relations, and enhancing freedom are your
they're my crude categories. Yeah.
Yeah. So I work with Nancy, and we do methodology stuff. So
you're Annette.
I'm Annette. So as a qualitative researcher, I'm going, right. Can you give us some of the backstory on what were like 2 or 3 categories that didn't make the final 3?
Yeah. Oh, you mean how did I pair? Oh, perfect. That's a great question. Okay. So when I'm trying to figure out what are the ones I'm going to showcase, there are all these ones I didn't put in.
Like equity.
Right. Like fairness, right? Or however one. So I am very insecure about these categories, I should say. So it takes a qualitative researcher to like pull apart, make me naked in front of you all. So one of the things that I
Take
am
it all off.
right. No, right. One of the things that I still have those dreams as a professor. I show up. One of the things that I am working with is making these more granular. So, I do have a list, and I got to say, I'm not going to, if I can remember what was also there. Competency. So, like, improving your own work, that is, challenging yourself to do better, for example. And that actually becomes a category later on in the book in terms of distribution, but I think it probably could be here too. Establishing essential relations can be pulled apart in lots of different ways. And really, as a first stab at the analysis of this data, this is crude. Look at this chart. Stata could produce some like really big, beautiful thing if I was doing it quantitatively. This is sort of, rudimentary. But these are large categories. And if you can imagine the way I would code it, so I have a code book on Atlas that has 300 categories. It has it has litigation, patent, copyright, it has license, and all of these terms, but it also has dignity, fairness, abuse, reputation. It has like all these other things which you're not hearing, right? But if I could sort those were all things that I added as I was reading, and then I would start attaching those codes to different parts of the transcript, and inevitably what happens is they start clumping, and I have to give the clumps names. But in those clumps, there's lots of codes attached to them. So like last night, I'm giving a talk in a couple of weeks to celebrate the 20th anniversary of one of the big fair use cases, Campbell versus Acuff Rose, about the Two Live Crew Pretty Woman song. And I've decided I'm going to talk about this fairness thing. And so I've started looking at all the parts of the interviews where people talk about unfair and fair. Those codes in particular. And what I'm seeing is what those codes are next to, how they're clumping. It's a difference. I'm getting something different, not unrelated, but it's a new dimension to the analysis. Really, what this is about is how does the IP story, the orthodox story, map onto these folks? And I think the crude mapping is good enough to make the case, which I want to make, which is we need to reform intellectual property law, and we need to stop talking about the way that IP is working when it's not. This is enough, but I think to sort of tell more specific stories about, like you're saying, to get more granular, right, you got to go back to the data and see what else it's telling you. But right, so competency was one of it, challenging yourself competency, the fairness, fair and unfair was there. I think I had, with reputation, I had like dignity harm and like derogatory dignity, like different forms of reputational injury was in there. So reputation is a whole chapter, but there's lots of different ways that reputation can be injured. So that would be an example of one category getting more granular. That's a great question.
Okay, we have treats outside.
Oh.
Join us outside and we can continue chatting with Jessica. Thank you.
Okay, thank you.